and this honorable court.
Thank you, Ms. Lindsay, and on behalf of Judge Bennett and Judge McBrayer, we are pleased to have counsel with us this morning for oral argument, which is being live streamed so that we may fulfill our duty to maintain open courts. We will conduct the hearing in the same fashion as if we were all together in the courtroom. Each side has 15 minutes, and the appellant has reserved 5 of his 15 for rebuttal. Unless there are any announcements, I'll ask Ms. Lindsay to call the case.
Sentry Select Insurance Company versus Tennessee Farmers Mutual Insurance Company et al.
All right, thank you. Mr. Raines, you have the floor.
Thank you, Your Honor. May it please the court, my name is Doug Raines. I represent plaintiff appellant Sentry Select Insurance Company. As the judge noted, I'd like to reserve 5 minutes for rebuttal. The issue, Your Honors, in this case is one of insurance law. And the issue is this: as between Sentry Select and Tennessee Farmers, which policy is primary and which policy is excess? Sentry and Tennessee Farm insured the same 9 pieces of farm equipment that were destroyed in a fire in March 2016. The value of the claim on an actual cash value basis was $1,158,500. Sentry and Tennessee Farm disagreed as to which policy was primary, so they split the claim 50-50, with each paying $579,250. Sentry then brought a declaratory judgment action in the circuit court, and then on cross motions for summary judgment, the circuit court ruled that Sentry's policy is primary. And with all due respect to the circuit court erred in this ruling. The circuit court ruled that Sentry's policy is primary, not on the basis of the other insurance provisions in the respective policies, but on the basis that Sentry's policy was written first in time. This contradicts the black letter law of this court. The Hartford accident case says that when 2 insurance companies insure the same property, it is immaterial which policy was written first, because both policies are on the risk at the time of the loss. So it is not which policy was written first that governs this question, Your Honors, but instead what governs this question is the respective other insurance provisions in the policies. And the other insurance provisions are in harmony, and when they are read in conjunction with each other, they yield the conclusion that Tennessee Farmers' policy is primary and Sentry's is excess. And there's a 3-step analysis that I want to take the court through that shows why this conclusion is correct. The first step is we ask the question, do the 2 policies insure the same 9 pieces of equipment? The answer is yes, and that's undisputed. The circuit court found that, and it's not been disputed in this case. The second question is to look to the other insurance provisions in the respective policies. The Sentry other insurance provision says the insured can have other insurance. And if the insured does have other insurance, and that other insurance is subject to the same plan, terms, conditions, and provisions as the Sentry commercial inland marine coverage, then Sentry's policy is pro rata with that other insurance. On the other hand, if the other insurance is not subject to the same plan, terms, conditions, and provisions as the Sentry policy, then Sentry's coverage obligation is excess over that coverage. So we see immediately, Your Honors, that at least as contemplated by the plain meaning of the terms of the other insurance provision in Sentry's policy, there's no circumstance in which Sentry's coverage can be primary. It's either pro rata or it's excess. So the question at step 2 then is Tennessee Farmers' policy subject to the same plan, terms, conditions, and provisions as the Sentry policy? And the answer, Your Honors, is no. And the answer is no, most apparently because the coverages are completely different. Sentry has commercial inland marine coverage, and Tennessee Farmers has property coverage. And in fact, Tennessee Farmers does not contest our assertion that its policy is not subject to the same plan, terms, conditions, and provisions. So the next step then is to look at what Tennessee Farmers' other insurance provision states. In its other insurance provision states, generally, Tennessee Farmers coverage is excess. However, if the insured has other insurance that is specifically written as excess over Tennessee Farmers insurance, then Tennessee Farmers insurance applies first. So the step 3 then.
The step 2 is where I struggle with your analysis. It seemed like to me that is a stretch of the language of the other insurance policy in the Tennessee Farmers policy. To me, these two provisions, if we agree with you that we're under part 2 of Sentry's other insurance, to me, I read those as repugnant to each other. And then we're back to the Continental Insurance case, and they're both negated. So we'd have a pro rata situation. I mean, to trigger, I guess my question is this, to trigger the other insurance policy provision in Tennessee Farmers to make it primary, doesn't it have to specifically reference Sentry or say something more than just the language that's in there?
Your Honor is correct in that the other insurance provision of Tennessee Farmers policy says that the other insurance has to specifically be written as excess. But I think Your Honor is incorrect to the extent Your Honor is suggesting that in order to be specifically written as excess, our policy would have had to refer to the Tennessee Farm policy, for instance, by name or by policy number. That would have been impossible.
Well, granted, that's true. But again, the Tennessee Farmers policy, the other insurance, talks about some sort of explicit provision saying, we're going to be excess. You don't get to the excess under the Sentry policy without going through a couple steps here. And it just seems to me to be a stretch of the language of the two policies here.
I don't think it's a stretch, Your Honor. I think it's fair to say that our policy in this circumstance is specifically written as excess by the virtue of the fact that Tennessee Farmers provision is not subject to the same plan, terms, and conditions and provisions as the Sentry policy. That fact alone renders our coverage excess. And because our coverage is rendered excess because of that, that means under Tennessee Farmers' other insurance provision, the Tennessee Farmers coverage applies first, which means that they are primary. Now, I take Your Honor's point about mutual repugnance. If this court were to determine that the two provisions are mutually repugnant with each other, then under the Continental Casualty case and a number of other cases in Tennessee, then the coverage would be pro rata between Sentry and Tennessee Farmers. That is correct. And I think Your Honor is also correct to suggest that it is the coverage provisions, the other insurance provisions that govern here. It is not which policy was written first. As I indicated before, that's what the Hartford accident case indicates. So if you read the two provisions in conjunction with each other, and this is step 3, and I believe that they are in harmony. In fact, the circuit court determined that the other insurance provisions were in harmony. The circuit court just didn't happen to go through the step-by-step process of applying the other insurance provisions. But if you read the two in conjunction with each other, under the analysis that I just laid out, Tennessee Farmers coverage is primary and Sentry's is excess. But again, as a fallback provision or a fallback argument, if this court determines that the provisions are mutually repugnant, then yes, the obligations of Sentry and Tennessee Farm are both pro rata. I'd like to address briefly the counter arguments that Tennessee Farmers presents. They present 4 counter arguments, only one of which relates to the provisions of the policies. The primary counter argument that Tennessee Farmers presents is that Mr. Jenkins, who is the insured in this case, his subjective, after the fact and extra contractual intent should govern here. He testified in his EUO and in his deposition that he intended for Sentry's coverage to be primary. The parole evidence rule bars consideration of that testimony because it contradicts the plain meaning of the terms of Sentry's policies. As I indicated before, Sentry's coverage is either pro rata or it's excess under the terms of its other insurance provisions. So Mr. Jenkins' intent that it be primary cannot be considered by this court under the parole evidence rule because it contradicts what Sentry's policy says. His testimony is also barred by the rule that says the exclusive province of this court is conclusions of law. A witness cannot testify as to conclusions of law. I see that my time is running out. I would respectfully request that the court reverse the circuit court decision and deem Tennessee Farmers policy primary, and I reserve the rest of my time. I thank the court for its attention.
Thank you, Mr. Raines. We'll hear from you on rebuttal. Mr. McClellan.
Thank you, Your Honor. My name is Art McClellan, a member of the Sumner County Bar and representing Tennessee Farmers, the appellee in this matter. Fortunately, as Mr. Raines pointed out, this matter was resolved with competing summary judgment motions in favor of Tennessee Farmers Mutual Insurance Company. As a result, the facts, the underlying facts of the matter are not in dispute, and it boils down to the interpretation of those facts in relationship with Tennessee jurisprudence.
So do you agree that there's no dispute here that the Tennessee Farmers policy and Sentry policy are not the same plan, terms, conditions, and provisions, so that we're not looking at F1 under the Sentry policy?
No, sir, I don't agree, because my position is, unlike what Mr. Raines pointed out, is that language in the Sentry policy is ambiguous. So we don't know what it means. What is the same plan? What are the same terms, and what are the same provisions? Basically, the purpose of the inland marine policy that Sentry Select issued was to allow that farm equipment to go across state lines, and there would be no effect on coverages. The Tennessee Farmers policy does exactly the same thing. In fact, if you look at the application of the terms of the two policies, although the Tennessee Farmers policy is termed a farm owner's policy, and the Sentry Select is termed a commercial inland marine policy, as to the coverages, as to these 9 pieces of farm equipment, those coverages and the application of coverages are identically the same. Our position has always been that when you read the Sentry Select policy and it uses the phraseology plan, terms, and provisions, we don't know what that means. We can't take a definition of those words and then go to the Tennessee Farmers policy to see if in fact they provide the same coverages to Mr. Jenkins as in the Sentry Select policies. So no, I don't agree, Judge, as to that aspect of Mr. Raines' argument.
Mr. McClellan, you say the Sentry policy is a marine policy that allows the insured equipment to go across state lines, but your client's policy is not a marine policy. And
No,
what does that mean?
Well, it's simply not a marine policy. It's a farm owner's policy by designation. The two policies, types of policies, are interpreted differently by the respective states' boards of insurance and banking. The purpose for the inland marine policy back in the 1900s, as the United States was expanding quickly, was to have insurance that would follow the goods across the United States during transportation, so that coverages were not affected by separate states. It would be uniform. The point I'm making, Judge Clements, relative to the two policies here, is that the Tennessee Farmers Policy likewise provides coverages for those 9 policies, whether they're in Tennessee, whether they're in Kentucky, whether they're in Alabama, whether they're in Missouri. The application of the Tennessee Farmers coverages are really identical to the inland marine coverages afforded by the Sentry Select policies. The difference is the 2 companies have decided to call them different things.
All right, thank you.
One of the things I did want to point out with regards to these undisputed facts is that policies of insurance are contracts. In this case, we're dealing with 2 contracts between Terry Jenkins and Sentry Select and Terry Jenkins, Sharon Jenkins Farm Credit Services and Tennessee Farmers Mutual Insurance Company. I point that out because it becomes very important when you do the analysis. Under Tennessee jurisprudence, all contracts, including policies of insurance, are to be interpreted such as to give effect to the party's intentions as reflected in those written contracts. Policy should be construed in whole and reasonable and logical manner so as to carry out those terms. I think it's important that we understand, as I pointed out in my brief, that Tennessee's jurisprudence gives effects to the party's intent as a layman would read it. An insured should, and I'm quoting from the Harrell versus Minnesota Mutual Insurance Company case, an insured should not have to consult a long list of case law or law review articles and treatises determines whether he has coverage or not under an insurance policy. If you look at the argument of Sentry Select, if Tennessee Farmers policy is in fact primary, Tennessee Farmers would have an obligation to pay the fair market value of those 9 pieces of farm equipment, but the payment would be made to Terry Jenkins, Sharon Jenkins, and Farm Credit Services. The 9 pieces of financed equipment with Deere & Company would not receive a penny because Deere & Company is not an insured. It's not a loss payee under the Tennessee Farmers policy.
But
So
it is under the Sentry policy?
It is under the Sentry policy.
Well, so why doesn't that undercut the argument you just made that there's, I mean, it seems like to me that's a different term then, and therefore we're not looking under F1 of the Sentry policy.
Well, I agree that the named insureds, and in this case, the loss payees are in fact not identically the same, because under the farm owner's policy, not only were the 9 pieces of farm equipment insured, but also the farm itself, the land. There were multiple other pieces of farm equipment beyond the 9 John Deere pieces that are the subject matter of this policy.
But am I right? So you're saying that the 9 John Deere pieces of equipment that were lost in the fire, they weren't all still encumbered? Some of them were owned outright?
No. All nine pieces of farm equipment that were destroyed in the fire were encumbered by a first mortgage lien to Deere & Company. There was some $900,000 owing at the time of the fire loss to Deere & Company. And that's my point, Judge. If the Sentry Select policy is not primary, the whole purpose for the Sentry Select policy goes away. The purpose for the Sentry Select policy's inception in the first instance was to protect Deere & Company, because Mr. Jenkins bought those 9 pieces of farm equipment totally with Deere Finance money. Deere Finance is not a loss payee under the Sentry Select policy. It's additional insured.
The loss payee under Tennessee Farmers policy is another finance company. Is that
That's correct. Farm Credit Services.
And what is Farm Credit Services' interest in these 9 pieces of equipment?
They have
s-
they have a second mortgage lien. They have a wraparound lien on all of Mr. Jenkins' personal
I see.
property and all of his real estate.
All right.
And that's what becomes problematic. Mr. Raines doesn't want you to consider Mr. Jenkins' intent. Well, don't consider Mr. Jenkins. Consider the intent of Deere Company, because the whole purpose of their requiring insurance on their 9 pieces of equipment was to allow, in the event of a loss, their financing to be totally paid by the insurance company. If Sentry Select is not primary, Deere Company does not get a penny. The only way Deere Company gets paid is for Sentry Select to be primary. And essentially, although Mr. Raines argues that the trial judge, that Judge Wooten, found that because Sentry Select was written first, that the timing was important, that's not what the judge determined. What he did mention the timing, because there was a 2-year differential between the time the Sentry Select policies were written and the time that the Tennessee Farmers policy was written. But the point that the Judge Wooten was making is this point I just made with you, is that the only way Sentry Select gets paid is if the only way Deere Company gets paid is if the Sentry Select policy is primary. If Tennessee Farmers primary, all that money goes to basically Farm Credit Services, because they had a first mortgage lien on not only the 9, they had a second mortgage lien on the 9 pieces, but they had a first mortgage lien on everything. Tennessee Farmers policy obligates us to pay Mr. and Mrs. Jenkins and Farm Credit. In that circumstance, if the ruling is Tennessee Farmers as primary, then Mr. Jenkins is standing there holding the bag to a $900,000 payment owing to Deere Company. That totally opposite, not only the intent of Tennessee Farmers, the intent of Mr. Jenkins, but the intent of Sentry Select and the intent of Deere Company. Sentry Select had that same intent because Deere Company is an additional insured in the Sentry Select policy, not a loss payee, an additional insured that's in the body of the policy itself. Let me refer you now, if it please the court, to the other insured provisions of the Tennessee Farmers policy. It consists of 2 sentences. It's very simple, it's very succinct, and it's very clear. And this is something that Mr. Raines wants to focus on the Sentry Select policy, but he ignores the Tennessee Farmers policy. That first sentence clearly says that Tennessee Farmers is excess and will only apply unless any other policy out there has been fully exhausted its payments regarding the loss. And then secondarily, and I think this is the question that Judge McBriar asked Mr. Raines regarding the specificity language in the second sentence of the Tennessee Farmers policy. And this is where the 2-year comes into play, is that the Sentry Select policy could not have been specifically written as excess because it was written 2 years prior to the inception of the Tennessee Farmers policy. So a very simple view of the Tennessee Farmers other insurance language sustains the position of Judge Wooten. The language is totally consistent with the intent of Deere Company, the intent of Mr. Jenkins, and the intent, for that matter, of Sentry Select in 2014 when the Sentry Select policy was initially written. It's our position, Your Honor, that the 2 policies are not repugnant. That is consistent with what Mr. Raines says. and is consistent with.
But that position, is that position contingent on us agreeing with you and the trial court, or I guess just your position that we come under F1 of the Sentry? In other words, if we were to disagree and say, well, these aren't the same terms and same plan terms, condition, and provisions of the two policies, just for the mere fact that you've got additional named insured or different named insureds under both policies, and that we find that we should be under F2 of the Sentry policy, it seems like to me then the policies are repugnant, or provisions are repugnant, because they both provide there will be excess.
I think you're correct, Judge. In the event that there's a determination of repugnancy, there's no question that based upon current prevailing case law in the state of Tennessee, the two policies, if repugnant, become pro rata. Sentry Select would still owe us some money, but they wouldn't owe us as much money if they were pro rata. There's no question about that, Judge, and I wouldn't attempt to argue otherwise, because that's clearly the law in the state of Tennessee. I would point out that those cases describing that are auto cases involving the same insureds and the same loss payees. Thank you, Honor, for your time and attention.
Thank you, Mr. McClellan. Mr. Wright.
Thank you, Your Honor. A couple of points that I would like to address that Mr. McClellan made. Going back to step 2 of the analysis that I provided the court initially, he now indicates that he believes our policy language is ambiguous. And as this court knows, ambiguity means has more than one reasonable interpretation. So although Tennessee Farmers argues our coverage or our policy provision is ambiguous, you'll note that Tennessee Farmers does not provide an alternative interpretation of Sentry's policy provision. So without an alternative interpretation, there can't be any ambiguity. Another point that Tennessee Farmers makes is that there's no difference in the coverages, even though Sentry's is commercial inland marine coverage and Tennessee Farmers is property coverage. The argument that Tennessee Farmers presents that there's no difference, even though they're different coverages. That's not the case. I would like to direct the court to volume 3 of the record, page 316. Paragraph 6, it provides specifically insured farm machinery. I'm reading from Tennessee Farmers policy now. It says when specifically insured farm machinery is shown in this endorsement, we cover those items specifically described in this endorsement on and within 500 miles of the insured premises. So there is a geographic limit to Tennessee Farmers coverage, whereas there is no geographic limit to Sentry's commercial inland marine coverage. So they are not the same. And that difference matters because it means that Tennessee Farmers policy is not subject to the same plan, terms, conditions, and provisions as our policy.
Would the name insureds, differences in the name insureds also be another indicator, or is that a sort of a red herring in this case?
No, I think that's true, Your Honor. I think Your Honor is right on the nose there. The fact that there are different named insureds is another example of how Tennessee Farmers policy is not subject to the same plan, terms, conditions, and provisions.
Is that a standard? Is that phrase a standard? Is that unique to Sentry's policy, or is that a standard insurance provision? So there's a lot of case law on interpreting how to read that.
I don't have a ready answer for that, unfortunately, Your Honor. I don't know if these are standard terms. It looks to me that Sentry's commercial inland marine policy, it looks to be fairly standard. So, but I don't want to venture a guess for the court.
Yeah, because I guess conceptually, someone could always argue under that provision, as long as it wasn't another Sentry policy, it's always going to be not the same, for no other reason that there's a different insurer.
Yes.
But I don't think it's meant to be read that precisely. And what is striking here is, of course, both policies covered the same loss due to fire. in that sense, they are the same. But, because we don't have a situation where this farm equipment was outside 500 miles. So does it matter what the loss was when you're reading this provision or not? And it sounds like there may or may not be case law. You just don't know.
Well, I will say this, Your Honor. I presume that the Commissioner of Tennessee Insurance has to approve the policy provisions that Sentry's writing policies in Tennessee. I assume the Commissioner approves the language. So to the extent that that is true, then it would seem to me that that would probably be a common policy provision. Now, to Your Honor's point,
Mr. Raines, before
yes.
you go to the next, Insurance Services Office's ISO writes most insurance policies. Are both of these policies written by ISO?
I'm not sure if that's in the record, Your Honor. And again, I don't have a ready answer, but I would presume that that is the case.
If it is, it'll say ISO at the bottom of the page or something. But
Yeah, unfortunately, I don't have a ready answer for, yes, it says ISO Properties Inc. at the bottom of Sentry's policy.
all right.
I want to address briefly the point about protecting the insured. And the argument is if Tennessee Farmers policy is primary, that somehow Mr. Jenkins would be left holding the bag. And that is simply not the case. If he had a debt with Deere and Company at the time of the loss and Tennessee Farmers coverage is primary, he simply would pay that debt out of the proceeds from Tennessee Farmers. And that would be the case regardless of whether my policy is primary, Tennessee Farmers policy is primary, or it's pro rata. That just doesn't matter. The state of his former debt is not going to change regardless of how this court rules. And the debt was satisfied over 4 years ago. I see that my time is up. May I conclude briefly, Your Honor?
Please do.
So in sum, I would respectfully request the court reverse the circuit court decision, remand with directions that the circuit court enter summary judgment for Sentry, declaring our policy primary and ordering Tennessee Farm to pay the $579,250 that we paid for this claim. I appreciate the court's attention.
All right. Thank you, Mr. Raines and Mr. McClellan. You've given us a lot to think about. Ms. Lindsay, please proceed.
This honorable court, pardon me, is in recess until 11 a.m.